Hey, what's up, guys? Gonna do this in just a second here. Alan, how you doing? Tucson police suck. Hello, Mad Cat, Nunya, Texas. Officer safety issues. Hello, everybody.
What are you doing?
Hey, I'm doing a live video.
What do you think you're doing?
A live video.
You talking to your homies?
Talking to my homies
What,
and my homettes.
all five of them?
All 30 right now.
Oh my gosh.
We're gonna do this video is called "The Lawsuit Against Olmos Park," a reading.
What?
So I'm gonna read the lawsuit here.
You know I'm gonna jack you up.
This just got funnier, guys.
Wait, I meant jack you off.
Never mind, the reading's canceled. All right. Hang on, I just wanted to share this real quick and then we will get
Off.
started. That was weird. So what I'm going to do, just so y'all know, what I'm going to do is I'm going to, because a lot of people haven't had a chance to see or hear about this, but we did file our lawsuit last week. I can't really, well, I
Hey, he's
can't,
only been home for like 2 weeks. Everything is quick until it balances out, okay?
yeah.
Look, it got you.
$2, mammy, you should go
Oh
down.
my gosh, scoot the chair out. Just scoot. No, let's give him a show. Scoot the chair out. Scoot it out. Scoot it out. Come on. Why are you so embarrassed?
I don't want this video getting banned on
Yeah, it won't
YouTube.
get banned. I'm just gonna sit on your lap, and it'll
Oh.
get you donations, babe. I'm all for it. Okay, let's do this.
All right, here you
Okay.
go. Oh, see, it's now your face is going to get me donations. They're like, man, we've been waiting for this. We've been giving all this money to CJ when we could have been giving more money to see that hot chick.
Am I supposed to bounce?
No, that's like 60 pounds you're putting on me.
Did you just say ouch?
All
He
right.
said ouch.
Uh,
Fuck this shit.
hey, watch your language there, baby. That's my wife. All right. So we're going to read the Almost Park. I wanted to read this to you because I want everybody to understand.
Wait, who's this lady?
Who's this lady? Where?
It's his wife.
Oh, yeah. All right.
I don't drink.
We actually don't
alcohol.
drink. We're just naturally this crazy.
We've been on each other's nerves for a while now.
This is the Almost Park lawsuit. I don't know if it's backwards for you guys or not.
Here, turn it this way and it won't be.
Oh no, it's not. It's
There.
not.
See? Good to go.
Yeah. All right. So it is filed. It's actually filed. It is 20 pages long, and it's finally happened. I can't talk about what led up to this. I can't talk about what's going on with the case. So all I'm going to tell you is what the case says. And if you have any questions, Emily, if you'll keep track of some of the comments.
Oh.
If somebody's got a question, I'll see if I can answer that. But
Well, can I turn it so I can see? Like,
yeah.
It'll still be on you.
Yeah, that's fine. All right, so plaintiffs Christopher Grisham and James Everard, by and through their attorneys, ex Colo Law.
Is this just gonna be you reading the whole thing?
Yeah, but I'm going to talk about it.
Oh my gosh.
What the? You're making this hard on me.
This is so boring now.
No, this is actually going to get really interesting.
Actually,
and what
it
I'm going to
is.
do, what I'm going to do is I'll skip the boring stuff like jurisdiction and venue and
So
stuff.
just
Who
go to the
cares?
end.
So anyway, the obviously here's the parties. So plaintiff, me, a law-abiding citizen of the state of Texas. Plaintiff, James Everard, a law-abiding citizen of the state of Texas. um, upon information and belief, all defendants are Texas residents and are being sued in their individual, supervisory, and or official capacities as permitted by law. So here are the defendants. Rene Valenciano, hereinafter defendant Valenciano, or defendant police chief Valenciano.
Are we allowed to make fun of their names?
You can make fun of whatever you want.
Oh, okay.
Defendant Valenciano was a Texas resident at all times relevant to this complaint and acted as a direct supervisor to the city of Olmos Park and police department employees. And as the chief of police, he is being sued in his individual supervisory and official capacity. Defendant Officer Jay Lopez was a Texas resident.
Did they catch that?
What's that?
Did they catch that?
What? Yeah, in his individual capacity
Individual
and his official
capacity
capacity.
and official capacity.
Defendant Officer Lopez was a Texas resident at all times and acted as an Olmos police officer. He is being sued in his individual capacity. Officer Hector Ruiz was a Texas resident at all times and acted as an Olmos police department. He is being sued in his individual capacity.
That would be another live video.
What?
Nothing. You keep reading.
Defendant Vieira, the guy that initially got there.
Hang on. Yes, it was filed in the right time frame. They were trying to let it slide, we think, because they weren't responding as we thought they should have. And literally, what was it like? A week?
It was filed before the statute of limitations ran out, before the 2 years. We tried to, and again, I can't get into the details, but we tried to work extra judiciously or without going to court. We tried to do the right thing and work through that process, and we didn't make it work, and so we gave them 2 years to come to their senses, and they did not.
Yeah.
So we filed the lawsuit. Vieira is being sued in his individual capacity.
See, no, like if we had planned this, like if I'd known he was going to do this, I would have had pictures of the cops in their freeze frame.
Yeah.
Of the arrest, where they're all like that and stuff, where the fat one's like, and it would have made it all the better for. Oh, you have it on your camera?
I thought I had some pictures of the officers.
I don't know, but I would have had like, like, hey, this officer right here, and the one that's like, what's the big one? The one that was all like, you need space to get his guns back.
Yeah.
And he's all like that, and
that's all of them. That's all the Olmos Park police officers.
Because some of them, and then you have Renee that has that look of like, I really don't know how to be a cop, but anyway. Okay.
All right. And then finally, defendant, City of Olmos Park.
That's his face. That's on his face.
You talking about my porn stash?
Yeah.
You're talking about my porn stash.
That's his face.
All right.
Don't hate on his face.
Here we go. Here are the factual allegations. On March 26, 2018, Plaintiff Grisham called Olmos Park Police and asked whether he would be approached by officers if he and others were openly carrying their firearms. He was assured by Chief of Police Valenciano that plaintiffs and others who are open carrying pursuant to Texas state law would not be approached by officers. On March 27, 2018, plaintiffs were walking on the public sidewalk while open carrying. Plaintiff Grisham had a handgun strapped to his waist. What?
Who's Hornberger?
Oh.
Oh. How come Hornberger not getting involved?
Oh, I don't know.
If you just want to hear the lawsuit, you can just file the FOIA and not be a part of it. That's,
Plaintiffs were walking on the public sidewalk while open carrying. Plaintiff Grisham had a handgun strapped to his waist. Plaintiff Everard had an unloaded rifle slung across his chest. Plaintiffs were both holding video cameras and recording the public view. Upon information and belief, a witness called 911 and explained that someone was carrying a gun. Lawful. The witness further explained that the men carrying the guns did not seem dangerous. True. He actually said that. Rather, they looked like they just wanted the attention. The 911 dispatcher said something to the effect of, "Those are the Second Amendment people." Let me read that one more time. The 911 dispatcher said something to the effect of, "Those are the Second Amendment people," i.e., they knew who we were before they got there.
Eggs are a hot commodity right now.
Yeah, it's going to take $10 donations to get an egg on my face.
Eggs on his face.
All right. Prior to arriving on the scene, the Olmos Park police officers were made aware the call was regarding the Second Amendment people. Officers arrived and plaintiffs began recording their interaction with the officers. Defendant Officer Lopez began yelling at Plaintiff Everard, stating, "Lay on down and disarm yourself, or we will fucking disarm you." Yes, that's what it says in the complaint.
That's a lot of good stuff in the complaint.
At this point, Plaintiff Grisham moved to the corner where Plaintiff Everard was standing, and he continued to film the interaction with the officers from that angle. Several other citizens were recording this interaction as well, and I do want to give a shout out to SA Ecstasy Prez, to News Now Community, to Jack Miller, and Texas Sheepdog, and the Batosai, and many others who were out there, Buck G, who were out there filming as well. Several other citizens were recording this interaction as well. Several cars drove past the scene. At one point, a lady stopped to chat with plaintiff Grisham, and a bicyclist casually strolled past the scene. An image of the scene can be found below, and there's a picture of the scene. Oh, you want to show that? Okay, so and that's from Batosai's video, I believe. Plaintiff Everard continued to ask the officers what crime he had committed. When asked to lay on the ground, he said he would comply if he was told why he was being detained.
Is that you?
That's me.
Oh, okay. I didn't realize you were that close to him before.
Yeah.
Valenciano showed up.
Then, yeah. So this is kind of this is right before the chief showed up here. You can see I've got my handgun. Jim's got his rifle, and that I believe is the Penguin. I mean Vieira. All right. Then defendant Valenciano and Officer Vieira approached plaintiffs. At this point, defendant Officer Vieira begins reaching for Grisham. Here, Grisham places his hands in the air and took several steps back. Defendant Valenciano, without prior warning, shot plaintiff Grisham with a taser, while defendant Vieira shoved plaintiff in his chest. An image of the scene can be found below. Those of you that have seen the live video, you see this. There's Valenciano right there aiming his taser from like 3 feet away at my back.
So, and when they had to take the barbs out, they had to like dig them out.
I had, instead of just normally pulling out the taser barbs, because he was so close to me when he did that, I actually had to have a surgeon come in to surgically remove the taser barbs because they were so far into my skin and you couldn't just pull them out. Jim doesn't know what's going on at that point. Yeah, Jim's over there like, hey, I don't know what's going on, man. They're just tasing CJ. I'm just gonna keep watch here. I got you. I'm just kidding. Jim had no idea. It all happened so quick.
Yeah.
If you look at the next picture, I mean, this is only like 2 frames away or 3 frames, and Jim's already turned it around. So I'm just busting his chops. Go follow Not So Slim Jim as well. All right, the tasing caused plaintiff Grisham to fall backward onto the pavement and smack his head on the pavement. Soon thereafter, it became apparent plaintiff is bleeding and seriously injured. Plaintiff Grisham suffered a concussion and a serious abrasion to the back of his head. An image of the scene can be found below. I just showed you that picture. 21. While plaintiff Grisham is being assaulted by defendant Valenciano and defendant Vieira, plaintiff Everard is placed under arrest by defendant Officer Ruiz. Once Officer Ruiz had plaintiff Everard cuffed, he took plaintiff Everard's camera and threw it into the street, breaking it. Then defendant Officer Ruiz pushed plaintiff Everard onto his knees. Once plaintiff Everard was on his knees, defendant Valenciano and defendant Ruiz shoved plaintiff Everard face first into the pavement for no lawful reason. The images of the scene can be found below. Again, many thanks to the Batosai. So if you go to the Batosai's channel, now you can see here, this is Jim being pushed over by Valenciano. He's got his hand on his head, and his hand on his back right there.
Oh, there's like a lot of comments.
So, defendant officers Ruiz. Oh, where am I? Oh, okay. Number 22. Defendant officers Lopez and Vieira attempted to lift plaintiff Grisham to his feet. Clearly disoriented and bleeding from the head, plaintiff Grisham was unable to gain solid footing. What's true here is I didn't even feel my legs. I don't even remember all of this. No, I'm not. But there was a point even when I was at the police station. We're going to interrupt
this time because he's not supposed to be talking about.
I'm not talking about the case. I'm talking about what happened that day.
Drink time.
All right. In response, defendant officer Lopez and defendant officer Vieira dragged plaintiff by his arms and legs to the police car. Soon after, EMS arrived and defendant Valenciano waved them away, denying medical treatment for plaintiff's serious injuries. And then an image of the scene can be found below. There's an image of me being dragged and or carried away to the police car. You'll notice I'm not walking at all. So, all right, 23. Valenciano had witnessed plaintiff Grisham struggle to gain his footing and saw that plaintiff had to be dragged to the police vehicle. Nevertheless, he waved away EMS, who could have provided plaintiff Grisham with the needed medical care. Defendant Valenciano then directed defendant officers to take a longer route back to the police station in order to further delay plaintiff Grisham's necessary medical treatment. 24.
You take a sip of your drink. Plaintiff Grisham suffered a serious abrasion to his head, a concussion, aggravated PTSD symptoms, and chronic migraines too. You threw me off.
They want to see you, not
no,
me.
They can see my frizzy hair. PTSD symptoms and chronic migraines due to his injuries. 25. Due to being thrown to the ground and face shoved into the pavement, Plaintiff Everard suffered a fractured wrist and a serious shoulder injury. Thereafter, Plaintiff Everard underwent shoulder surgery to repair the damage caused by the unlawful arrest.
Ah, crap.
What?
They paid enough for an egg. What's wrong with you people?
6. When defendant Valenciano removed Plaintiff Everard from the squad car, he used excessive force, causing injury, ligament damage to plaintiff's wrist and his hand. Valenciano used force on Everard. It's right there. Once again, when he asked about plaintiff Grisham's injuries. 27. After defendants arrested plaintiffs, defendant Valenciano called over the radio that he squashed the rebels.
Squashed the rebels.
Yeah, that's in quotations.
Or as he said, squashed the rebel.
Yeah, he said rebel. 28. Once defendant officers had plaintiffs detained at the police station, they proceeded to destroy plaintiff's property, specifically the SD cards from the video camera and GoPro and cell phones of both plaintiffs were deleted. 29.
Jeez, you got like everybody out there is probably getting turned on now by your porn voice.
Okay, sometimes there's a lot to read. I'm making it interesting. You're
just liking it. As a matter of fact, someone said I'm changing my vote. Emily gets the egg. So keep reading.
Yeah, I'm good with this. He's saying he doesn't like me. No, I don't like you either. Moreover, officers made false statements that Everard's gun was loaded. That Mr. Everard's gun was equipped with armor-piercing ammunition, a felony in Texas, and that Mr. Everard refused to display his identification. None of these statements are true. Mr. Everard had done nothing unlawful. Watt 30, while at the station, plaintiff Everard was held at taser point and forced into leg shackles while being called derogatory names such as retard by defendant officers. 31. Plaintiffs were both held in a small room for 8 hours in handcuffs and shackles. One officer tried to remove the shackles once they arrived at the station, per standard practice, but defendant Chief Valenciano required the shackles remain on plaintiffs. At no point were plaintiffs combative or flight risk to defendants. The shackles were not used for legitimate safety reasons. Instead, Chief did so for maximum pain and discomfort as well as humiliation. The shackles were tight and caused pain to plaintiffs.
They were, and they hurt.
Yeah.
They were very uncomfortable. You couldn't get comfortable at all.
Oh,
Those
I know
things
when you guys
hurt.
came home, your hands were
all we've got
swollen.
Pictures of our bruises and stuff from the shackles.
32. Plaintiffs were refused food and phone... Sorry. Oh, I'm blocking your face.
No, I just can't read.
Oh, okay. Plaintiffs were refused food, phone calls, and answers to their questions. Several officers... Did you burp up freaking nasty... Oh. That was gross. 32. Plaintiffs were refused food, phone calls, and answers to their questions. Several officers intentionally ate food in front of the plaintiffs. You do that to me all the time. 33.
A man's got to eat.
Yeah. Plaintiff Grisham requested and was denied a phone call to his attorney and to everyone else. They didn't tell anyone where they were. We didn't find out where you guys were until 4 o'clock in the morning?
Yeah, it was way after midnight.
And because you called me, no one knew where you were. Okay. 34. When they were finally transferred to San Antonio, they were held at taser point and in full physical restraints to sign their property paperwork.
No comment, Greg.
What did he say? What did he say? Can I say?
No comment.
the funny thing. Okay, 35. Upon information and can we say anything about the property paperwork about how they messed it up, and then they didn't actually give you guys the?
Yeah, when we signed for our property, so Jim went out first, and then I went out, and when I went to go sign my property receipt, it was wrong. And so there were some of the things that were on Jim's property, or that was Jim's property, that was on my property receipt. And so obviously I don't ever sign anything without reading it, especially if it's the police giving it to me. And so I read it, I noticed it was wrong, and I asked the officers very cordially, I'm like, okay, look, these don't belong to me. What do you want me to do? Do you want me to mark it out, or do you want to redo it? What do you want to do with this? And instead of just telling me, well, just cross it out and then initial, or instead of telling me, well, we'll redo it, they angrily grabbed me and took me back to the cell, forced me back into my cell for like a few more hours after that. And I didn't even know until later. I can't say what happened after that because this is going to be evidence stuff.
Yeah.
But what they did with that property receipt is going to bite them in the ass. We'll just say that.
For those of you that like ass.
Yeah. There are a lot of problems that are going to come up in this case. That it's not just what everybody saw on camera with what happened to me and Jim, but everything that they did inside the cell before we ever got moved out is just.
Are you sure that you're not just an ass as opposed to you eat ass? I'm just clarifying that. Okay, what number were we on?
We were on 35.
Okay, and then after these short ones, I'll let you read the long ones. 35. Upon information and belief, defendant officers were acting or otherwise responding to the scene pursuant ordinance 24-8 do you say the dash?
Dash 84.
Dash 84. This order is unconstitutional and is superseded by state law. 36. There is a lengthy history of Olmos officers harassing Second Amendment demonstrators. In fact, several other videos online depict similar instances of police misconduct being perpetrated by some of the same officers who were present and involved in the March 27, 2018 incident. 37. Plaintiff Grisham was charged with interference with duties of a public servant, obstruction of a passageway roadway, resisting arrest, and assault.
Not just any assault. Felony assault on a peace officer.
Yeah. 38. Plaintiff Everard was charged with interference with the duties of a public servant, obstruction of a passageway roadway, and disorderly conduct. We should go back to those pictures and just see what, you know. 39. 2 days later, on March 29, 2018, Olmos City Council repealed the ordinance 24-84, explaining that it violated state law. Ugh. 40. Later, all charges against plaintiffs were dropped. 41. Upon information and belief, the Olmos Park Police Department, its officers, and defendant Police Chief Valenciano have communicated with other surrounding police departments in an effort to stop Second Amendment activists from exercising their First Amendment rights. Mother effers. That wasn't in there. 42. Upon information and belief, defendant Chief Valenciano and defendant officers have constructed and carried out plans to get Second Amendment activists off of the public sidewalk.
And First Amendment activists as well.
Well,
all right, 43. Olmos Park officers are trained to forcefully pressure Second Amendment protesters to stop protesting even when protesters are compliant with state and federal law. 44. On multiple occasions, defendants have cited Second Amendment activists with bogus charges. Such charges are typically dropped prior to trial as they are meritless. All right, here's what we're suing them for, okay? Those are the facts. That was the statement of facts there. Here's what we're suing them for. Count 1. Plaintiffs restate and count 1. Violation of civil rights under 42 U.S.C. Section 1983, Fourth Amendment, excessive force. Plaintiffs restate and incorporate by reference each and every allegation set forth in all prior or allegations. At all times relevant herein, defendants were acting under the color of state law. Defendants' use of force was objectively unreasonable. Defendants never gave plaintiffs a lawful order. Defendants did not have reasonable suspicion to detain plaintiffs. Defendants did not have probable cause to arrest the plaintiffs. At no time.
That's an insult.
What? Where?
Look like brother and sister.
We just been married so long. Hey, we're in Texas. It's all right. Give me a kiss, sister. All right. At no point did Plaintiff Everard resist officers. Nevertheless, officers. Wait, no, you can't hear me now?
No, that was, I think it's delayed, so it was from, yeah.
All right. Nevertheless, officers unreasonably cuffed and shoved Plaintiff Everard. Plaintiff Everard never exhibited any signs of violence, nor did officers suspect Plaintiff Everard of being a violent criminal. Defendants acted unreasonable when they tased and shoved Plaintiff Grisham for backing away from an officer who was unlawfully attempting to detain and otherwise seize Plaintiff Grisham. Plaintiff Grisham exhibited no signs of violence, and he was not suspected of being a violent criminal. Defendants used unreasonable force when holding plaintiffs at taser point once in full body restraints. 51, defendants were not in a high pressure situation that would require split-second decisions. 52, defendants used so much force on plaintiffs so as to cause Plaintiff Grisham to sustain a concussion and a serious abrasion to his head. Defendants used so much force on Plaintiff Everard that they broke his wrist and caused him a significant soldier injury for which he was required to receive surgery. At all times relevant, defendants were required to obey the laws of the United States. At all times relevant, plaintiffs had a clearly established right to be free from excessive force of this nature. 56. At all times relevant, defendants intentionally, knowingly, maliciously, recklessly, unreasonably, and or grossly negligently used excessive force on plaintiffs. As a direct and proximate result of defendants' unlawful actions, plaintiffs suffered damages for their physical, mental, and emotional injury, and for pain, mental anguish, humiliation, and embarrassment. That was count 1. This is count 2. Violation of civil rights under 42 U.S.C. Section 1983. Fourth Amendment, unlawful arrest. 58. This is Section 58. That's what all these numbers are. Plaintiffs restate, and I'm not going to read the first paragraph of each of these because it's just legal mumbo jumbo. 59. At all times relevant herein, defendants were acting under the color of state law. 60. Defendants acted unreasonably and unlawfully when they arrested plaintiffs absent probable cause. 61. A reasonable officer in the defendant's position would have understood that probable cause did not exist for an arrest. 62. At all times relevant, defendants were required to obey the laws of the United States. At all times relevant. 63. At all times relevant, plaintiffs had a clearly established right to be free from arrest absent probable cause. 64. At all times relevant, well, there's another egg.
Okay.
Thank you, what does that say? Jahalazar?
Okay, so we will do an egg. It might not be on this video, but we will do an egg. Maybe, do you want to do it?
We'll do it tomorrow.
Yeah, tonight, it's already, 44 degrees outside?
Yeah.
And we're not going to put that egg on our porch where it's already wet and muddy. So
we'll do the egg tomorrow.
Tomorrow.
Thank you for the donation.
We might even do 2 eggs if someone's going to bring us
You
a
get an
egg.
egg.
No, I do not get an egg.
Yep, there was a vote. I saw it, and it was the the deciding vote.
That was a man vote, and
you get an egg.
I'm not getting an egg. You guys have to pay $100 for me to get an egg.
Well, I guess I'll just fertilize your eggs then.
Did you guys hear my daughter? Okay, I'm not getting an egg.
All right.
I have to fornicate with this porn stash. I don't get an egg. I deserve. Yeah, I won't go there. Never mind.
All right. At all times relevant, defendants intentionally, knowingly, maliciously, recklessly, unreasonably, and or grossly negligently furthered malicious prosecution against the plaintiffs. As a direct and proximate result of defendants' unlawful actions, plaintiffs suffered damages for their mental, emotional, and physical health, injury and pain, mental anguish, humiliation, and embarrassment. All right. Count 3. We're only on count 3, guys. Count 3, violation of civil rights under 42 U.S.C. 1983, First Amendment, unlawfully preventing protected conduct.
At this point, yes, it is
Yes.
a civil suit. If it goes to court, that's when it becomes you add in damages and all that stuff.
But yeah,
So
this is a civil suit. We have gone to the prosecutors already, and they just haven't. They just didn't do anything with it. So we tried the criminal side. It just didn't work. Maybe once the civil case comes out.
tell them
Well,
again.
it doesn't matter now because the statute of limitations. I guess we have to figure out what the statute of limitations are for each of these crimes.
Yeah, and tell them again which court it was filed in because a lot of people weren't here at the
It
beginning.
was it's in the Western District of Texas federal court. So
Federal.
federal court. All right, count 3. Violation of civil rights under 42 U.S.C. 1983. First Amendment, unlawfully preventing protected conduct, Section 66. Plaintiffs restate and incorporate by reference each and every allegation set forth in all prior paragraphs. 67. At all times relevant, defendants were acting under the color of state law. 68. Plaintiffs have a First Amendment right to be present on public sidewalks. 69. Plaintiffs have a statutory right to be present on public sidewalks in Texas while openly carrying a firearm. 70. Plaintiffs were engaged in constitutionally protected conduct when they were recording while openly carrying on a public sidewalk. 71. Defendants tased, shoved, and arrested plaintiffs while they were exercising their First Amendment right to record officers on a public sidewalk. 72. Defendants intentionally, knowingly, maliciously, recklessly, and or unreasonably prevented plaintiffs from recording police officers conducting their duties. 73. Plaintiffs had a clearly established constitutional right to protect or to record the police. Hang on, let me finish this section.
Okay.
74. The defendant's acts deprived plaintiffs of the rights, privileges, and immunities guaranteed to citizens of the United States by the First and 14th Amendments to the Constitution of the United States and in violation of 42 U.S.C. 1983. And 75. As a proximate cause of the illegal and unconstitutional acts of defendants, plaintiffs were harmed and suffered damages as a result. Okay, before we get to count 4, what?
Okay, so I know people are talking about like no less than 5 million. So the way some of like these lawsuits work and stuff like that, you don't get money that high unless you actually go to trial. And
Well, you also, you have to go to trial, but
that's actually if they award you that, and it mostly comes from like punitive damages.
and you pretty much have to be shot.
Yeah.
No one gets over $1 million unless you've actually been shot.
Yeah.
Or if you've been permanently disfigured or paralyzed.
Yeah, some kind of physical damaging. I mean, we'd like to say, yeah, oh man, I hope we get, millions from these people. But in most cases, it's probably not going to happen, even though we think, yeah, that what they did, we're owed this much money or whatever. But just so you guys know, it's probably not going to happen, even though we think it should happen.
Now, if it goes to a jury, it could.
Yeah, it could, because depending on what the jury thinks it was.
Keep in mind that in federal civil suits, only 0.9% of all cases filed ever make it to a jury.
Yeah. Generally,
they're always settled. And I can't talk about the specifics, but we don't have any problems settling, provided that certain conditions are met. Okay?
There's a difference between getting tased and from getting shot with a bullet. And it's weird how damages are weighed out in that aspect.
But don't worry, we're not going to let them get away with what they did.
But once this is all said and done, I don't want people to be like, "Oh my gosh, you should have done this." And I just want you guys to know that that's not how things work in the legal world. It's not like we can go in there saying we want $5 million, and it's just not how it is. That's just not how it works at all.
It's the way it should be, but it's
sometimes.
I mean, anytime civil rights are violated, even if it was just being put in handcuffs for no reason for 5 minutes and you didn't get injured at all or anything, I think civil rights violations, it should be an automatic $1 million windfall for the victim. It should just be that way. It should just be that way. But don't worry, we're not, even if we, and again, I can't get into the case, but y'all know me. Even if there's a settlement and it doesn't go to trial, it's because I felt and Jim felt like the punishment or whatever the other side was going to happen was worthwhile. And we do have some criteria that we've communicated to our attorneys on what that is, what that threshold is. So, but I can't talk about that. So just know they're not going to get away with it. It's going to hurt. Okay. Just like they hurt us, it's going to hurt them. All right. Count 4. And I don't mean physically. That wasn't a threat. Count 4, violation of civil rights under 42 USC 1983. So this is the fourth count that we're alleging. First Amendment retaliation for protected conduct. You know, Leon Valley likes to use retaliation. Well, we've got a retaliation as well.
It comes from their city insurance.
Yeah.
So not out of their own pocket. It comes from their city insurance.
Well, we're suing the officers individually, though.
Yeah. So I'm not sure how that actually plays out, but
yeah,
it's typically from their city insurance.
That's funny. Someone toilet papered my house. Now it's appraised at $850,000. All right. So this is count 4. Let's go to 77. At all times relevant, defendants were acting under the color of state law. 78. Plaintiffs have a First Amendment right to be present on public sidewalks. 79. Plaintiffs have a statutory right to be present on public sidewalks while open carrying a firearm in Texas. 80. Plaintiffs were engaged in constitutionally protected conduct when they were recording while open carrying on a public sidewalk. Defendants have frequently targeted plaintiffs and others engaged in similar displays as plaintiffs. 82. In retaliation for engaging in protective conduct, defendants arrested plaintiffs for carrying firearms and recording the public view on a public sidewalk. 83. Officers had no knowledge or information that would lead a reasonable officer in their situation to believe that there was probable cause to arrest plaintiffs. 84. At all times relevant, I'm just not going to read the section numbers because that's just a legal thing. That it kind of throws off the stuff. So I'm not going to read the section numbers anymore.
We can't talk about that, about an NDA right now. We do know that that's a part of
any negotiation is the NDA. So I won't say, because that's an active part of our case. I'm not going to say what my preference is because I guarantee you Olmos Park is watching this video. At all times relevant, defendants intentionally, knowingly, maliciously, recklessly, unreasonably, and grossly negligently retaliated against plaintiffs for engaging in protected conduct.
So I think the only thing that, as far as Jack's arrest, that can be added in there were the previous arrests that happened before CJ's arrest and Jim's arrest. You can't add what happened after that.
Well, there is a way to use ongoing conduct even after what happened to us to create a pattern of misbehavior.
Sometimes it's hurtful, and depending on sometimes it can help and sometimes it can't. So you just want to add what happened prior to, not what happened
just
after.
Know that our attorneys, it's Excolo Law, EXCOLO. They are amazing, and they are fighters, as well as Adam Funk with down in Houston. These guys are fighters as well. We have got a dynamite team of attorneys this is their bread and butter. Okay, these are trial attorneys. These aren't attorneys who are just going to roll over and take an easy out. Okay, we've got fighters. All right, count 5. This is 42 USC 1983, Fourth Amendment, unlawful search and seizure this time. Plaintiffs restate and incorporate by reference each and every allegation set forth in all prior paragraphs. At all times relevant herein, defendants were acting under the color of law. And I'll pause one more thing too. I think you guys know by now that I do demand justice and accountability. So just know that I will not stop fighting until there is justice and accountability. Okay, it's not just justice and it's not just accountability. It's both justice and accountability, because nobody should have to go through what I went through, what Jim went through, what Jack went through, what Buck G went through, what they've done to all of these people in Olmos Park. This lawsuit is designed, along with whoever else is filing lawsuits, is designed to put a stop to that against everyone. Okay, and that's why we're going to fight this very aggressively. Everyone. All right. Defendants did not have reasonable suspicion to stop plaintiffs. Defendants never gave plaintiffs a lawful order. Defendants did not have probable cause to arrest and search plaintiffs. There's 6 more. But we're not going to read all of it, just the counts. At all times relevant, defendants were required to obey the laws of the United States. Yes, the cops have to obey the law. At all times relevant, plaintiffs had a clearly established right to be free from unlawful search and seizure of this nature. At all times relevant, defendants intentionally, knowingly, maliciously, recklessly, unreasonably, and or grossly negligently unlawfully searched and seized plaintiffs. As a direct and proximate result of defendants' unlawful actions, plaintiffs suffered damages for their physical, mental, emotional injury.
Let's take a break.
No, I'm almost done.
No, this is going on for too long.
Okay, I'm going to finish it.
Okay, hold on.
Count 6. I'll tell you what, I'll just go to the meat. I won't read all the stuff that's... This is the one I like. This is a good one here.
If we could have filed without a lawyer, but whoa, it's got blurry.
We could have done
like
pro se, but I want to make sure everything is done 100% right. And so we've got some really, really good attorneys on this, and
probably it would not have gone far, and we would not have gotten.
We wouldn't be where we're at now without some big wig attorneys helping us.
I would say, yeah.
Count 6 is, again, 42 U.S.C. 1983 violation for a failure to intervene. So defendants observed excessive force and other constitutional violations being committed by their counterparts. Defendants had the opportunity and the means to prevent them from occurring. Defendants stood by and let the harm unfold. The events did not unfold in a matter of seconds, giving defendants ample opportunity and time to intervene. At all times relevant, plaintiffs had a clearly established right to be free from state actors' failure to intervene. And so that's the failure to intervene. At all times relevant, defendants intentionally, knowingly, maliciously, recklessly, unreasonably, and are grossly negligently allowed their fellow officers to use excessive force against plaintiffs and otherwise violate plaintiffs' constitutional and statutory rights. All right, count 7. What was that?
Yeah, I already
up
that.
Count 7. 14th Amendment, deprivation of property.
Okay.
And you don't have to read, just start here.
Oh, okay.
You don't have to read numbers.
Defendants deprived plaintiffs of their property without due process of law when they threw and destroyed defendant Everard's camera, when they wiped the memory cards of plaintiff's GoPro and cell phones. Defendants seized and destroyed plaintiff's property without a court order or without a hearing where plaintiffs could be meaningfully heard. At all times relevant, plaintiffs had a clearly established right not to have their property seized and destroyed absent a warrant or a court order. At all times relevant, defendants intentionally, knowingly, maliciously, recklessly, unreasonably, and or grossly negligently deprive plaintiffs of their property without due process of law. As a direct and proximate result of defendants...
You don't have to read that section.
Okay.
That's the same one in every count.
So
count 8. Same 1983 violation, 14th Amendment, failure to provide medical care.
Yeah.
Start with 114.
Yeah. Okay. The 14th Amendment to the United States Constitution requires state officials to provide medical care to individuals injured in their custody. As discussed herein, both plaintiffs were severely injured by the force used by defendants. Instead of promptly providing medical attention, Defendant Chief Valenciano waved away the EMS vehicle and first responders who had arrived at the scene to take plaintiffs to the hospital. They were told to keep it moving instead of providing treatment. After denying proper medical attention, Defendant Valenciano later instructs his officers to take a longer than necessary route for no reason other than to prolong plaintiff's suffering. At the police station, Defendant Valenciano ordered WMS. Was it supposed to be?
I think it's supposed to be EMS.
Yeah, EMS to stay back and not provide care to Plaintiff Grisham, who was nearly passing out. He could not stand up on his own, nor did he know the date. Defendant Valenciano intentionally delayed, denied, and interfered with medical treatment when plaintiffs were obviously severely injured. Defendants' acts and omissions demonstrate deliberate indifference to plaintiffs' serious medical needs in violation of the 4th and 14th Amendment to the Constitution. And do you need to read that?
42 U.S.C. 1983.
Yeah. As a proximate result of the illegal and unconstitutional acts of defendants, plaintiff was harmed and suffered damages for her
for
their physical, mental, emotional injury and pain, fright and shock, mental anguish, humiliation, and embarrassment.
You don't have to read that one. Count 9, malicious prosecution.
Okay, defendants played an integral part in the prosecution of plaintiffs when they cited plaintiffs with tickets that were wholly unsupported by any legal basis or probable cause. Defendants prosecuted plaintiffs with malice when they cited plaintiffs despite any legal basis to do so in order to stop plaintiffs from exercising their First Amendment and statutorily protected rights. Defendants prosecuted plaintiffs with malice when they made false statements regarding the conduct of plaintiffs and the ammunition possessed by plaintiffs. Defendants demonstrated malice in prosecuting plaintiffs through various other dishonest actions previously stated. Defendants did not have probable cause for citing plaintiffs because defendants never had reasonable suspicion to stop plaintiffs. Defendants never gave plaintiffs a law of order, and plaintiffs never engaged in any conduct which a reasonable officer would believe gave him or her probable cause to cite plaintiffs. Plaintiffs' proceedings terminated in their favor. At all times relevant, defendants were required to obey the laws of the United States. At all times relevant, plaintiffs had a clearly established right to be free from malicious prosecution. At all times...
don't worry about that.
Okay.
That's the end, normal end. All right, count 10.
Liability.
Oh, no, this is just liability. All right.
Municipal liability. Defendants, officers' actions, and the actions of the Olmos Park Police Department in previous open carry instances, so this is talking about previous open carry, demonstrate a policy, practice, or custom to deprive plaintiffs and other open carry activists of their First Amendment rights. On multiple occasions, individual defendants in the Olmos Park Police Department have detained, arrested, or otherwise charged Second Amendment activists for open carrying per Texas state law.
And that's the thing, because usually they can try the whole qualified immunity thing, but because they've attacked activists that were lawfully open carrying several times prior to what happened to us, and as everybody knows, I had contacted the city over a week. It was about 12 days prior to us going out there. I contacted the city and filed an open records request. When that open records request was ignored, I made a phone call to the chief, and in that phone call was another follow-up where, so the city council was made aware that this continuing conduct was going on. The chief was made aware that this continuing conduct was going on. Thankfully, I had the foresight to record the conversation with the chief, because that shows that he knew that what he was about to do the next day was illegal, and he knew that it was wrong. So there goes, he's not going to be able to claim qualified immunity because I've got him on tape, and the city council, so the city can't claim that they've got qualified immunity because they were put on notice about this as well. So that's what this is going. How does your phone call prior to the chief affect or help your case? It really helps our case, I think. In my opinion, I think it helps our case. Absolutely. Without that, it could be a he said, she said. But I think we're going to be able to go in there, and I think that phone call is going to be very damning evidence on our behalf.
Okay. Time and time again, defendants have cited Second Amendment activists with meritless charges only to have these charges dropped prior to trial. Despite the fact that these charges are frequently dropped, defendants continue to cite Second Amendment activists in hopes to curtail the activists from exercising their First Amendment rights. Defendants' actions and inactions constitute an impermissible policy, practice, or custom that deprive plaintiffs of their right to be free from retaliation for protected conduct. At all times relevant, plaintiffs had a clearly established right to be free from unlawful policies, practices, and customs. Ordinance 24-84 was unlawful as it conflicted with Texas law permitting the open carry of firearms. Thus, it was an unlawful policy or custom which was the moving force behind plaintiffs' injuries.
And they were made aware of that. They were made aware of the law. The question is, if they don't have qualified immunity, they're really covered by insurance. Actually, yes, because they need insurance for when they're not covered by qualified immunity, because they don't need insurance if they get qualified immunity, because there's no claim. There's no case if they've got qualified immunity. So that's what the insurance is for. At least as far as we know, it's not like Olmos Park or Leon Valley, where Leon Valley just openly says, well, that's all right, we've got insurance for these civil rights things. I mean, the lawsuits against Olmos Park, they're going to easily be able to show that they don't care. There's a reckless indifference to the kind of conduct that they show against activists, and they've even said, oh, we've got insurance, we can violate their rights all day long, it doesn't matter.
Okay. The city council is the final policymaker for defendant city. Even if Ordinance 24-84 was not unlawful, it was an officially adopted policy that had plainly obviously consequences resulting in a constitutional violation. Further, the city had notice of such recurring constitutional violations stemming from Ordinance 24-84. As a direct and proximate result of defendant cities' unlawful actions, plaintiffs suffer damage for their physical, mental, and emotional injury, and for pain, mental anguish, humiliation, and embarrassment.
And what that really means is that when where was it? I was like, oh, the 2484 ordinance. This was the ordinance that they had that said no loaded firearms in public on public streets. That was the ordinance, the unlawful ordinance, and they repealed that 2 days after our arrest because they knew it was unlawful. I already made them aware that it was unlawful. I have those emails to each of the city councilmen, the city attorney, the city manager, and the chief of police as well. So everything leading up to that was is up there. So, all right, this is the final part. This is the prayer for relief. Whereas plaintiffs Christopher Grisham and James Everard demand judgment and praise for the following relief jointly and severally against all defendants. A, full and fair compensatory damages in an amount to be determined by a jury. Punitive damages in an amount to be determined by a jury. Reasonable attorney's fees and costs of this action, and any other relief as appears just and proper. The jury plaintiff hereby demands a trial by jury of all issues so triable pursuant to the Federal Rules of Civil Procedure 38B. That, my friends, is the lawsuit. 20 pages of everything that Olmos Park did wrong. They have officially been served and are aware of the lawsuit. Again, I can't talk about. You're not going to hear updates like how things are going. You're not going to hear about the negotiations. You're not going to hear about what they're offering or what we're offering until this is all settled. But I wanted to at least get it out there. If you want to look up the case yourself in the it's the United States District Court in the Western District of Texas, San Antonio Division. That's where we're suing them. And all you got to do is look up Grisham and Everard v. Olmos Park et al. Probably, but it's versus Rene Valenciano, J. Lopez, Hector Ruiz, Aviera, and the city of Olmos Park. We do have a case number. This copy that I printed out, I don't have the case number on it, but there is a case number. I don't know how the federal courts work it. I know a lot of the county courts you can follow a court or a case. So everything now has been done. The lawsuit's been filed. They've been given notice, so service, and now we move into, all the pretrial stuff. So this isn't about the case. This is just in general because I am a law student and civil procedure is something I've been paying a lot of close attention to.
Here we go again.
But so now that this has all been done, several things would happen generally. So I'm not saying if these have or will happen in our case, but usually after you've got service of process, the defendant has 21 days to file an answer. If they waive service of process, they've got 60 days to file an answer. Now there are also pretrial motions within that, okay? And that's if there were any settlement negotiations, those would be happening within the 60 days as well. Once they file an answer, we have a chance to respond as well. We have a chance to amend the complaint at that point. Once we amend the complaint, they can file an answer to the amended complaint. I don't think we're going to amend anything because we have stated a claim from which relief should be granted, which is a part of 12B6 in the Rules of Procedure. So everything's been done right. I've given it my first year law student seal of approval, which means it probably sucks. I don't know because I'm just a first year law student. No, it's actually a really good lawsuit. So what this really means is if this were to go to trial, it probably won't go to trial for at least 10 to 12 months. And At least. And with all the courts shut down anyway, who knows? I mean, everything's getting backlogged. So I'm going to say it's going to be at least 1 to 2 years before this goes
Kind of how
to a
long
trial.
this live has lasted.
Yeah. So, all right. Any further questions? It looks like we're going to keep this under an hour, which is good. It is frustrating the way that, I mean, it was even Shakespeare even said that the speed of government was a problem. I mean, or the speed of the courts was an issue way back when. So it's been recognized for eons that the courts work slowly. But keep in mind, especially at a case of this seriousness, you want it. You want it to move and done right, not done fast. And I'm willing to be patient for justice. If y'all go to trial, will it be an open court? Yeah, usually it is. Federal courts are always open. There's no reason. This isn't a case that involves minors. It does involve police officers who act like children, but it doesn't involve minors. It doesn't involve rape victims. So there are some narrow reasons why a court would not allow an open court. So once it does go to trial, and if it does go to trial, trust me, I'll let everybody know when it is. So if y'all want to show up and watch the proceedings, because you have that right to do that, we'll make sure everybody's aware of when the case does go to trial. And anything that I can tell you about as far as the case progressing, I will definitely do that. Keep y'all updated as well. And finally, I'll leave you with this, that what's not important to me, and I don't want you to think that obviously I don't care about this, but what's least important to me is the money. What I want is justice and accountability. Those are the only two things I want. Now, there are only certain ways to get justice and accountability in our courts, and one of them is money. But there are other things as well. And so, but what's important to me and what I will not leave this case without is justice and accountability. That is my singular focus. And whatever that looks like in the end is what it's going to look like. And whether y'all understand it or not, I mean, hopefully, because I don't want anybody else to have to go through what I went through. I don't want anyone else to have to go through what Jim went through. And I don't want anyone else to have to go through what Buck G went through, and what Jack went through, and what Todd went through, and all these other people who have been victims of Olmos Park. If you look at the history, every single time there's been an incident in Olmos Park with activists, it's gotten steadily more and more and more violent. There isn't anywhere else for Olmos Park to go except to start killing people. And if we don't hold them accountable now, I'm afraid Olmos Park is going to start killing people, not just tasing them, not just throwing them on the ground, not just breaking their airsoft rifles, not just breaking their wrists or shoulders, but they're going to start permanently disfiguring, paralyzing, or killing people, because that's the only way that they're going to get that adrenaline rush if they get away with this. And I can't let that happen. My conscience cannot allow that to happen, because if I don't do something, and Jim feels the same way, if we don't do something, we have failed everyone that comes after us that is a victim of Olmos Park Police Department. So, and I definitely agree they should lose their Leo certificates. I absolutely 100%, that is my belief. Unfortunately, one of the things you cannot do is you can't say in your prayer for relief, you can't say we demand that they be fired. Unfortunately, that's not the way the courts work. That you can't, that's an employment issue. The courts aren't there to tell people or businesses or government entities who should and shouldn't be fired. So, but that's my personal belief, is that none of those people, my personal belief is that Olmos Park Police Department should be just completely dismantled. And San Antonio should take over law enforcement of that community. And those officers that are currently badged there, except for there's one, well, okay, there's an exception. Let's just put it that way. I won't say why or how, but that police department needs to be disbanded, and everyone involved in it needs to be nowhere near authority in any way whatsoever. accept the authority to mow the lawn. That's about it. All right. Any other questions? Should be in prison. I agree with that as well. I think I got all the questions, so we're going to go ahead and end this. My wife is like, yes.
He talks all day long. All day.
I do not. I play Fortnite all day long.
Yeah, and you talk to your little teenage friends like, oh, come get me in the helicopter.
All right. My prayers are with you. May justice be served. Thank you, sir. Yes, I agree. I personally think the settlement should be way into the 7 figures to the point the local residents feel the pain. Look, I wouldn't be upset with 7 figures. I'll tell you that much. But that's not, honestly, I'm not looking for money, but I understand that the only way you're going to get justice is through money. If they don't feel it in the pocketbook, it won't. I do know that my wife is beautiful. She is. I don't know how I got lucky, but she also makes beautiful kids. Right, Chris?
That look like our siblings.
Not bad for a brother and sister who got married. All right, y'all. Hey, take care. Be safe.
Remind us about the egg tomorrow.
Oh yeah. That the egg thing will happen. You guys donated. You donated some money, so Emily will get an egg.
No, he'll get an egg. He'll get 2 eggs.
No, you're supposed to get it.
No.
Someone said, okay, we both need to get an egg.
Okay, I didn't agree to the egg. It started out with you getting an egg, and you're gonna get an egg, not me.
All right, y'all. Take care. Be safe. Be free.
I deal with other bodily fluids on me, and I'm not gonna deal with an egg.